Hi everyone, Justin Drash with Fly Guy Law YouTube channel. This video is sponsored by Thaley Drash, attorneys and counselors at law. It's a Jacksonville law firm and they do personal injury all throughout the state of Florida. The reason why I wanted to do this video is due to the dramatic increase of Baker Acts that we've seen since 2015. In 2018 and 2019, in Florida, there were in excess of 210,000 people that were Baker Acted. Of those, 37,000 were children. So it's very important for parents to understand their rights under the Baker Act. So Florida Statute 394 is more commonly known as the Baker Act, and it can be quite daunting and confusing when somebody looks at it, especially when you're going through an emotional situation, oftentimes a emergency situation for a family. Maybe the breadwinner is being detained. Maybe somebody has to get back to their job, get to school, take care of children. There's a whole host of reasons why you'd want to go ahead and look and find out what the rights that you have under the Baker Act are. So I just wanted to start out with Florida Statute 394-463. And so a lot of people think that, okay, well, the 72 hours is a license to hold somebody, carte blanche. And oftentimes the Baker Act receiving facilities will tell people that, well, we can hold you for 72 hours. That's not entirely true. Okay, under the statute, that 72 hours is a time period within which they have to do one of four things. They have to either release the patient without any conditions, they have to release the patient for voluntary outpatient treatment, they can request that the patient give consent to be admitted on a voluntary inpatient treatment, and that's often a tricky endeavor, or they have to file a petition for involuntary placement with the appropriate circuit court. Now, oftentimes, Baker Act receiving facilities are going to try to scare people and say, well, if you don't sign voluntary, we're going to take you to court. We're going to keep you longer. Okay, well, that's undue influence and that's pressure. And that's not really a voluntary action. And what people have to understand is that once somebody signs voluntary, they've essentially taken the court out of the scrutiny process of whether their detention is lawful or not. So going to court's actually a good thing under the Baker Act. And having a attorney that is experienced with Baker Act trials is paramount. So typically what we see is we see a case where they file a petition for involuntary placement, and they oftentimes don't tell the person that they filed it. And then maybe in the context of a child, they'll file a petition on a child, and they won't tell the parents. And I know this sounds kind of unbelievable, but once you're in this position, you can look back at the video and go ahead and click like or subscribe if this happens to you. They're going to try to say that they can't provide you information. They can't provide you the petition. And oftentimes the Baker Act receiving facilities hide behind HIPAA. And you're the one that owns your private information. So you can have access to it. If any place is telling you can't have access to your records, that's kind of fishy, and you should start asking questions. Okay, so moving along, the Baker Act even says that confinement's not appropriate when any apparent harm can be avoided through the help of willing family members or friends. So in most cases, if we're dealing with a child, it's appropriate for the child to be at home with the parents, not in a cinder block facility where they're going to be exposed to children that have serious issues. And listen, there are those people out there. But keeping your children away from the children with the serious issues is extremely important. The last thing that you want is a child being in there and having a tendency to try to make friends with the people that are in there. That's just not going to be conducive to their mental health. So Florida Statute 394459 has a whole litany of rights that people are entitled to. And oftentimes we'll see cases where a Baker Act receiving facility won't let somebody have access to a telephone, or the calls between the family and the patient are in some way hindered or restricted or not even allowed sometimes. That's illegal. They can't do that. Likewise, people are allowed to send mail, okay? And it's got to be given to the person, and it's got to be unopened unless they have a really good reason. And that's going to have to be documented in the clinical record. So in my experience, I have never seen a good reason to inhibit the mail coming in. So we're going to move down a little bit and talk about a couple other portions of the Baker Act. Now, Florida Statute 394467 allows for any attorney representing the patient to have access to the patient, to the witnesses, and the records relevant to the presentation of the patient's case, and shall represent the interests of the patient. So what does that mean? That means that a Baker Act receiving facility can't restrict an attorney like me from speaking with the client patient. They can't restrict an attorney from talking to witnesses. And so, who may be a witness in a Baker Act proceeding? There's several. Okay, obviously the patient, that's going to be a potential witness. If we're talking a child, the parents could be witnesses. Oftentimes people on the treatment team would be a witness. So a Baker Act requires a first and a second opinion in order for it to be legally filed. And those two doctors that gave the first and second opinions are witnesses that an attorney should be able to interview. And I can count on my hand how many times a Baker Act receiving facility has allowed me to, without court intervention, interview a witness. And typically what happens is I'll get to a hearing, and based upon reputation or the threat of having to testify, and they know that the person didn't meet the criteria to be Baker Acted in the first place, they want to keep that person from testifying. So let's talk about what's required in order for somebody to be lawfully Baker Acted. The first thing that you have to have is a mental illness. Okay? And just because somebody has a mental illness doesn't mean that they can be Baker Acted. There are millions of people in this country that are walking around with mental illnesses, and they're fine. They're operating. They're not a threat to themselves or others, and they're not neglecting themselves. Okay? But the Baker Act criteria is but for the mental illness, and because that mental illness, that person is a threat to themselves or others, or a danger of neglecting themselves. So, for example, I've had a client before who had a foot injury and went to the emergency room, and we're talking an infection of the foot to the point where the individual couldn't walk. And in the ER, the person said, "It hurts so bad, I wish I was dead." Okay, well, this individual also had a bipolar diagnosis. Okay, but, and of course, the reason why I came into the picture is this person was Baker Acted. So their bipolar diagnosis had absolutely nothing to do with the statement that they made where they said they wish they were dead. It was the extreme pain that was being suffered from a physical injury, an infection on a foot with an open wound. So a hospital and a Baker Act facility will try to hinge on those words. And now, one of the things that we see is once they get you there, they try to replay these words every single day so they can justify keeping somebody there. And in a lot of cases, the reason why they'd want to hold somebody there is because of the insurance that is available. And so the more insurance that's available, the more the incentive is to hold somebody there. So let's go down a little bit and let's talk about Florida Statute 394-459-10. And that's a powerful statute because it says that any person who violates or abuses any rights or privileges of patients provided by this part is liable for damages as determined by law. Any person who acts in good faith in compliance with the provisions of this part is immune from civil or criminal liability for his or her actions in connection with the admission, diagnosis, treatment, or discharge of a patient to or from a facility. However, this section does not relieve any person from liability if such person commits negligence. Okay, so what does that mean? If a Baker Act receiving facility violates the rights that are set out and protect a patient under Florida Statute 394-459, they can be liable for civil damages. We'd like the case not to get that far. You would rather have your liberty than a really good case against a Baker Act receiving facility. So how do you know that you've got an issue? How do you know that there's likely fraud involved? Okay, well, you know, your sixth sense is going to be important, especially as a parent. If something doesn't seem right, it probably isn't. And so I'd like to go over some fraud indicators that we often see. So if a facility denies an attorney access to a client, that should raise the hair on the back of your neck, okay? Because a client has an absolute right to speak with their attorney at any time that's reasonable. And so if it's 2 o'clock in the morning, my clients can call me if they want to. And there's no law that says that they can't, because they might need advice about something that's happening. And so that's an important factor to consider. Denying family members access to the client. We see this time and time again where like a husband or a wife isn't allowed to speak to their loved one. Now, oftentimes they'll say, and especially in this day and age, they'll say, oh, okay, well, we've got a COVID protocol. Or we don't have visiting hours because of this, or we're short-staffed. Well, that's not your problem, okay? That's their problem, and that's something that's not going to trump what the law says. And with our experience, we've seen many Baker Act receiving facilities that will say, well, this is against our policy. But the problem is a policy of a Baker Act receiving facility does not trump a Florida statute or the Constitution. They would like it to, but it doesn't. All right, so the third fraud indicator is a failure to provide informed consent. So what is informed consent? They need to give a conscious explanation of what the treatment plan is. If there's medication that they want to provide, they can't just tell you to, pop this in. They have to provide this in written form, and you have to know what you're taking and why. Okay, it's very important. And we see this right abused on nearly a daily basis. All right, the fourth fraud indicator is hurrying or pressuring a patient to sign documents during the intake. Okay, oftentimes we'll see intake video where a Baker Act receiving facility, they'll just put a document in front of somebody and just tell them to hurry up and sign it because, hey, they need to go and do something else. They don't want you to know what the documents say. Typically, the documents that they want you to sign and not read are the ones that explain what your rights are. Okay. Also, what they want you to do is they want you to sign in voluntary. Okay. And I say voluntary with a quote around it. The reason why they would want you to sign involuntary, remember back when we were talking about 394-463, where the court doesn't have its scrutiny anymore. Okay, if they sign involuntary, well now they've got you. Okay, and if you ask to be released, AMA or against medical advice, then that presents a new timeline, and it complicates the entire matter, and it gives them more time to bill your insurance company. Okay, determination of how long treatment will last based on insurance coverage. So if insurance coverage is showing that there's 10 days for mental health in any given year, and somebody at intake is told that they're going to be there for 10 days, that should raise a really big red flag to you. Most people have been to the doctor and know that, if, depending upon what bone you've broken, for example, a radiologist or an orthopedic surgeon can look at an x-ray and they can give you a pretty decent estimate of when you're going to be able to put weight back on a foot or a leg, or when you're going to be able to come out of a cast. For a mental health issue, and I want to also explain that there are no scientific tests to test for a mental health disorder. To put a time that somebody is going to be recovered based upon the insurance is a very large indicator of insurance fraud. Okay, failure of a facility to inform a client of the right to habeas corpus. Whenever I speak with a client, I like to ask them the question, have you heard the words habeas corpus? Have you seen them? And in a overwhelming majority of the cases, they have not. And also when you talk to a client who's being detained at a Baker Act receiving facility, well, all these papers that they had signed, especially the ones that talk about rights, most of the time those papers are taken back from the person. So they want you to sign them real quick and then they take them back and they don't have access to them because they don't want you to know what your rights are. So when a facility doesn't tell somebody about their right to habeas corpus, which is Latin for bring the body before me, which is going to get court scrutiny, that is essentially the person's only way out of the facility. So if they don't tell them about that legal right, which they're required under Florida Statute 394-459, paragraph 8, if they don't provide you with that right, they've trampled all over your rights under the Baker Act. So that's a huge red flag because that's going to keep you in longer. When facilities use paper records and not electronic records. So we've seen cases where, in 2021 even, there's facilities that still use paper records. And the reason why they use paper records is because they can shuffle the pages. They can pull pages and add pages. And when you make a records request and they're going to tell you, oh, well, you can't have the records until after you've been discharged. Okay, that's going to give them the opportunity, especially if something was made a grievance to the patient advocate. That's going to give them the opportunity to try to fix the record. So a big red flag, paper records and not using electronic records. Now, facilities oftentimes will refuse to let people see their own medical records. Now, this one befuddles me, okay? And they'll say, okay, well, we can't because of HIPAA. And again, that doesn't make any sense. You have a right to see your medical records. And there's very few occasions where that would not be true, okay? But you're entitled to see the first opinion and the second opinion and the petition for involuntary placement. If they tell you you can't see them, or they mailed them, okay? It's 2021. We can email things. We can fax things. If they tell you that you can't see them or they're going to mail them, there's a fraud indicator for you. Now, one of the hardest things to do is to get a hold of a client at a Baker Act receiving facility. And so a facility will pass you around on the phone and they'll make it very difficult to reach a client. And so maybe there's a password or a PIN number that you have to give in order to speak to somebody. That's nowhere in the statute, and they try to hide behind HIPAA, saying, "Okay, well, we got to protect the person's information." Okay, well, they're more concerned about HIPAA than they are about a patient rights issue. So, whenever you get kicked around on the phone, that's another indicator. It shouldn't be that hard. And in nearly every case that I get, I see creative ways to try to make it look like we can't get a hold of somebody. Nobody knows anything about this person. Oh, you need to speak to the nurse before you talk to the patient. We're just getting plain hung up on. That happens a lot. Facilities or employees refuse to provide their last names or license number to you. You wouldn't believe how many times this happens. Okay, so when patients are trying to identify and hold accountable the people that are abusing their rights, okay, well, Lisa or Tom isn't going to cut it. You don't have a way to look up on the Florida licensing website who that person is. Okay, so they'll oftentimes say, okay, well, I'm not going to give that. I don't want to, give that, or it's policy, or it's for security purposes. Well, that's just simply a cop out. It's the reason why that they're not giving that information is because they don't want to be subpoenaed, or they don't want to be sued, or they're doing something bad. So people should be able to know who the providers are. And I feel that's a part of informed consent. I want to know who this person is. I want to be able to go and research what their experience is. All right. The last fraud indicator, and this isn't an all-inclusive list, but this is the ones that we see most often. But the last one is facilities and employees act like they don't know the date and the time of the Baker Act hearing. They're the ones that file the petition for involuntary placement. They know when these hearings are. You can just imagine why they wouldn't want a patient or a patient's attorney to know when the Baker Act hearing is. However, we've got a workaround for that. All right, so that is about all. I hope that you do your due diligence and go ahead and research the Baker Act in the event that you find yourself on the unfortunate end of a Baker acting, or one of your family members, or even a child. There's a lot of resources out there. My law firm, Thaley Drash, is certainly a resource. We encourage you to look at the materials that we've got posted online. Thank you for your attention, and have a great day.